Penalty clauses and liquidated damages. A contract may attempt to make provision for the recovery of damages in the event of a breach, setting out what the innocent party will recover. This can be a good way of trying to reduce the uncertainty of going to court to find out how much it considers as recoverable. There are two different types of clause for this situation, and it's important to understand the difference, since one type of clause is likely to be treated as binding by a court and the other as unenforceable. The two types of clauses are a liquidated damages clause and a penalty clause. As I say, it is important to get this right. Penalty clauses are not enforceable. Liquidated damages clauses are binding. Liquidated damage is a legal shorthand for a clause which represents a genuine, realistic pre-estimate of loss which a party would suffer in the event of breach of contract. As long as the clause is found to be a liquidated damage clause, the courts will uphold the recovery of the sum specified in the clause without the claimant needing to prove actual loss in that particular case. Conversely, a penalty clause is perhaps defined by exception. It provides for recovery of a sum which is not a genuine pre-estimate of loss. A penalty clause, as the name sounds, is seen as a form of threat to compel performance. You need to be able to tell whether a clause is a penalty clause or a liquidated damages clause, and the House of Lords, in the case of Dunlop Pneumatic Tyre and New Garage, set out a 5-step test for making this determination. The first principle is that the name of the clause is relevant but not conclusive. However, I would suggest avoiding calling your clause a penalty clause. Second, take the greatest possible loss under the contract. If the pre-agreed sum is extravagant and unconscionable, the clause will be a penalty clause. Thirdly, if the sum payable in the event of non-payment of a sum of money is greater than the sum which should have been paid, i.e. the contract provides for recovery for more than is actually lost when it comes to a sum of money, the clause is a penalty clause. Fourth, if a set sum of money is pre-agreed to cover any breach, both very small ones and very large ones, it is likely, but not necessarily, that the clause is a penalty clause. And lastly, just because a precise pre-estimate of loss is not possible, the fact that the parties have attempted a reasonable pre-estimate of loss does not turn the clause into a penalty clause. Clearly there is a degree of overlap and potential for confusion here, and a degree of pragmatism is needed. The burden of proof falls on the party who is liable to pay out under the contract if they want to try to argue that the clause in question is an unenforceable penalty clause, and the authority for this is Robophone Facilities and blank. You sometimes see in a contract a clause stating that the parties agree that this clause represents a genuine, realistic pre-estimate of loss. Such a clause is not decisive, and it doesn't prevent a party from challenging the clause, nor from a court finding that the clause is indeed a penalty clause. See the Duffin and Frabo case.